Ms. Brown and our illustrious Citizens Review panel. I wanted to bring a few things to your attention. I am speaking for myself and on behalf of the ACLU Texas Central Texas chapter. There are many things we don't know and that you are privy to or will be privy to tonight. And we put a lot of trust in your hands to work through all of those details and come to conclusions, recommendations that are necessary to hand over to the police chief. But the reason we don't know is we don't have the video, and people have touched on that tonight. But I want to let you know that where we are on discipline for not using video in the current draft of the disciplinary matrix. A year ago, I did get this draft, and it said a written reprimand for the first violation. Very recently, I asked for if there was an update of the draft, and in fact there was. I was surprised to note that it was a written reprimand to 1 to 3 day suspension for a first violation. I think the chief is preparing for the fallout of this particular case. I believe that's not enough. I echo Ms. Benini's comments that we need a much, much harsher sentence, for lack of a better word, punishment for any lack of video being turned on when use of force has been in play, whether or not injury or death has occurred. It protects the officers and it protects the public. It's good for everybody. There's nothing to hide. That said, another thing I wanted to bring to your attention tonight as you're considering all of these pieces of this particular case is this, as Mr. Linder mentioned, is a good time, I believe, to review the Department of Justice recommendations in terms of the use of force policy. As you know, we have back from them half of the review, which is the use of force policy review. We still await the specific incidents review, which may be a while in coming. But two pieces I want to point you to tonight in that Department of Justice letter that they sent. That's about 50 pages. On page 5, it talks about the Supreme Court holding that deadly force is permissible only when a suspect poses an immediate threat of serious physical harm to the officer and another person. It goes on to describe the different cases that relate to that. It says, APD's use of force policy does not comport with these legal standards in all respects. Accordingly, we recommend that APD revise its use of force policy to incorporate these constitutional standards, and goes on to detail that. One last thing, if you would allow me to mention on page 7 and 8, they talk about the language in the use of force, which is actually called response to resistance, which in some ways I find insulting because it assumes resistance on a citizen's part at any given interaction with the citizen, instead of talking about what force is permissible. But in this it says that APD should revise this particular statement about the ultimate test is whether the use of force was objectively reasonable, because it's overarching in nature. It further goes on in that section on page 8 to talk about the different pieces it should fix. One of them is a continuum of force, which the police chief is not fond of implementing. And I think this is a time to make him fond of that. And the second piece I do want to bring your attention to is that they should emphasize announcements of officers' presence. So please take a look at that carefully tonight in the proceedings. I appreciate your time.
Thank you so much.